Welcome to a special edition of the Machinist News Network. I'm Tanya Hutchins with IAM General Counsel Mark Schneider to talk about the U.S. Supreme Court decision on the case Harris versus Quinn, which deals with home health care workers in Illinois.
This was a big case for unions. It was decided on the last day of the Supreme Court's business for the year, and it was kind of a bit of a split case, split victory for the unions and for the people that oppose unions. In the public sector, which is where this case is, mostly if all the workers together want to join a union and pay dues, everyone has to pay their fair share of dues. It's like a potluck dinner where everyone has to bring a dish. And it's not fair if you don't, because the union has to represent all of the workers in the location. And so it's only fair that there be a fair share payment scheme. Well, in this case, the Right to Work Committee, a group of anti-union activists, brought a case saying that the public sector should be just like a right to work state, where if someone doesn't want to pay, they don't have to pay. So they get all the benefits of unionization. The union has to represent them and spend all that money, but the member doesn't have to pay anything. And this kind of regime is very difficult for unions to operate in. And what the court did is it awarded a kind of mixed verdict. It did not do what the Right to Work Committee wanted and say that all of the public sector is right to work. What it did say is that these particular home health care workers in Illinois really are not what they call full-fledged public employees, and therefore they don't have to pay dues if they don't want to. Now, the difficulty in the decision is who is a full-fledged public employee and who is not a full-fledged public employee. And I guess we'll have to wait over time to see how that plays out. But it most certainly affects these public sector workers in Illinois. Will certainly have some effect on kind of stay-at-home workers, workers who work outside a traditional workplace. And whether it has a broader effect than not in the public sector, not clear. It won't have a direct effect on a private sector, so it won't, for instance, much of the IAM membership will not be affected directly. We stand in solidarity, though, with the workers that are affected, and this is a bad decision. Even though it wasn't as bad as it could be, it leaves you feeling that the court is political. It was another one of these 5-4 decisions where the 5 right-wing judges wrote this decision and the 4 more moderate judges opposed. And the claim is based on the free speech rights of these dissenting workers, an odd kind of free speech right. Here would be a free speech right of a home health care worker to say, I don't want a raise. So it's kind of a fictitious free speech right. It's another one of a long string of decisions where the Supreme Court seems to feel that the only people that really have free speech rights are corporations and people who hate unions. Because when it comes to the unions, we almost never win those kinds of cases. So it leaves one feeling a little cynical about the court on the one hand. On the other hand, it could have been worse because it really is only affecting a narrow group of public sector workers.
So what happens next?
Well, what happens next is an interesting question. For these particular affected workers in Illinois who happen to be represented by the Service Employees Union, they're going to have to go out and make sure that those people pay dues voluntarily, because I happen to know a little bit about that situation. They've benefited greatly by being union. And I know that the SEIU is committed to keeping that union strong in Illinois, but they're going to have to do a little work to get those people to continue to voluntarily pay dues. The question is whether there can be a legislative fix in the state of Illinois or a legislative fix in other states that have similar systems that would enable the union to keep collecting dues as it has in the past, or whether the unions involved, and these are, again, largely public sector unions, AFSCME and SEIU, whether they're going to have to go out and redouble their efforts to make clear to those workers how important it is to remain union so that they can keep doing the kind of good work they do. there's been an attempt to divide us, as often in the past when management opposes unions. And the division we've seen over the last several years is the public sector versus the private sector. There's been an attack on teachers, police officers, firemen, these home care workers. What we need to do is show solidarity with these workers. Now, we represent some, but mostly not. But when they lose, we lose, because their wages and our wages are related. And it's a fight for all of us against the people opposed to us. This is funded by the same people that fight us, the Koch brothers and the big corporations. And we need to stand firm with our brothers and sisters in the public sector and see this thing through. It's hardly a death knell, but it's going to take work, and I'm sure that IAM strongly is going to support the fight that's going on now in the public sector.